A customer walks into a A customer walks into a pharmacy, hands over her phone number, and asks the pharmacist to message her when her medicine arrives. Question: does the pharmacist now need to present her a notice and capture Section 6, consent with a clear affirmative action, before sending that message? No. And the reason why is today's subject. She volunteered the number for a purpose she herself specified, and the law is sensible enough not to demand consent ceremony on top of obvious cooperation. That common sense ground and its precise limits is where the legitimate user's lane begins, and right beside it sits the ground every employer in India runs on daily: employment, with edges far sharper than most HR departments assume. Today, the two workhorse legitimate uses of the private economy, and exactly where each one stops. You're listening to DPDP Daily. I'm Harmeet Singh Kapoor. I've spent my career running large programs and portfolios, the discipline of making complex things actually happen, and for the past few years, I've brought that discipline to India's data protection law. I wrote the DPDP Act Compliance Handbook, From Law to Ground Reality, and this show is that book, opened up one episode at a time. If you're new here, the 30-second background: in 2023, India passed its first comprehensive data protection law, the Digital Personal Data Protection Act. In November 2025, the government notified the rules that make it operational on a phased clock that runs to full enforcement in May 2027. Together, they decide what every company, hospital, school, app, and shopkeeper in this country may do with your personal data, and what you can demand when they get it wrong. 15 minutes a day, no jargon, real answers. Let's get into it. First, the architecture reminder from episode 14, because it disciplines everything today. Section 7 is a closed list. These aren't examples of a flexible principle. They're the entire second lane. If your processing doesn't fit a listed use as described, the lane is shut and you're back at the consent door. With that fixed, let's take the two grounds that carry the private sector. Ground 1, voluntary provision. The Act permits processing for the specified purpose for which the data principal has voluntarily provided her personal data, where she has not indicated that she does not consent to its use. Unpack the three components because each is a boundary. Voluntarily provided, she gave it of her own motion in the course of seeking or receiving something. The pharmacy number, the address given to the courier, the email shared to receive an invoice. Contrast data you harvested, inferred, scraped, or acquired from a third party. None of that is provided by her at all, and this ground never touches it. For the specified purpose, and here's where the optimism dies. The processing this ground permits is processing for the purpose the provision itself specified, the purpose evident in the transaction. The number given for a delivery update supports the delivery update. It does not thereby become fuel for the marketing database, the cross-sell campaign, or the partner sharing arrangement. Purpose creep is precisely what this ground does not license, and I'd wager it becomes one of the most litigated boundaries in the whole Act, because an entire generation of Indian business practice, collect once, market forever, sits on the wrong side of it. And the negative indication check: she hasn't signaled that she doesn't consent. Tell the shopkeeper, use this only for the delivery, no promotions, and that indication binds, which carries a system design implication almost nobody has built for. Your intake channels need somewhere for such indications to land and be honored, because a preference expressed to a human at a counter that never reaches your CRM is a violation queued for later. Used well, this ground is liberating. It's the law's recognition that ordinary transactional cooperation doesn't need consent theater, the answer to the overcompliance failure mode from our early episodes, where companies pester users to reconsent to what cooperation already covered. Used greedily, it's a trap, because every stretch beyond the transaction's evident purpose is processing without any basis at all. Ground 2, employment. The Act permits processing for the purposes of employment. The framework speaks to safeguarding the employer from loss or liability and the provision of any service or benefit sought by an employee and the machinery of the employment relationship generally. Understand first why this ground exists, because the reason draws its edges. Employee consent is structurally suspect. Yesterday's free analysis told you why. When refusing costs you your livelihood's goodwill, a checkbox proves little. Rather than build the employment relationship on fictional voluntariness, the Act gives it its own lane. Payroll, attendance, statutory deductions, performance management, background verification proportionate to the role, protecting company systems and property, administering the benefits an employee asks for. The ordinary machinery runs here without consent ceremony and legitimately so. Now the edges, and every HR listener should hear these as the actual content of the episode. Edge 1. Employment purposes is a purpose test, not a personnel test. It covers processing the employment relationship, genuinely requires not everything an employer happens to want about the people it employs. Edge 2. The live wire, monitoring and surveillance. Protecting the employer from loss plausibly supports proportionate security measures, access logs, endpoint controls on company systems. It does not write a blank check for surveillance maximalism. The keystroke logging, always on webcam, location tracking after hours, end of the market, is claiming this ground far beyond what purposes of employment will bear. And remember the constitutional current from the Puttaswamy episode? Proportionality reads along with this act, and disproportionate means fail even where a purpose is legitimate. My standing advice to employers: for each monitoring measure, write down the specific employment purpose, the necessity case, and the less intrusive alternatives considered. If the memo is hard to write, the measure is hard to defend. Edge 3. Candidates and alumni. Recruitment processing sits comfortably near this ground's logic, but the file of the candidate you rejected 3 years ago and the ex-employee data drifting forever. The employment purpose has ended, and with it, this ground's cover. Retention needs its own justification and its own schedule, which is exactly the questionnaire item most organizations failed in episode 13. And Edge 4, the ground covers the employment relationship. It doesn't convert employee data into a general corporate asset for analytics, product experiments, or sale. One craft point ties both grounds together, and it's this episode's homework. For every activity you place in the legitimate uses lane, write the one-line basis statement, which Section 7 ground, and why this activity fits inside it. Delivery updates, voluntary provision, number given for this purpose at order. Attendance biometrics, employment, statutory wage and attendance compliance, proportionate to purpose. An hour of one-liners does two things. It forces the honest sort. The activities that resist a one-liner are your consent lane refugees in denial, and it deposits, yet again, into the evidence file, because when the board asks on what basis, the organization that answers in writing, dated years earlier, is having a very different conversation than the one improvising. Tomorrow, part 2 of the lane, the state cluster, the legal obligation cluster, and the emergency cluster, subsidies and services, court orders and compliance with law, medical emergencies, epidemics and disasters, including the guardrail that runs under all of them. No legitimate use anywhere in this list ever spells marketing. That's today's episode of DPDP Daily. If it made this law a little clearer, do one thing for me. Send it to one person who needs it. That's how this show grows. Everything I covered today, with the templates, checklists, and audit frameworks behind it, is in my book, the DPDP Act Compliance Handbook, From Law to Ground Reality. And I post one practical DPDP insight every morning. Find me on LinkedIn and on X and Facebook as well, under Harmeet S. Kapoor. One important note: this is education, not legal advice. For decisions about your organization or your rights, take proper professional advice on your specific facts. New episode every day. I'll see you tomorrow.